Welcome to this episode of Ask Amy. Thank you so much for joining us today. Eric Kwartler is the managing attorney for the Lone Star Legal Aid's Eviction Right to Counsel. Thanks so much for coming in.
It's my pleasure.
We wanted to talk to you because we get a ton of questions from renters. I believe, I know years ago I saw a stat that said about half of everyone in Houston were renters instead of homeowners. We're renting, whether it's a house or whether it's an apartment. Maybe you know that stat, or if I'm wrong on that.
I'd say that's very conservative.
That's very conservative. I mean, it's a lot. We have a lot of renters, so we get a lot of questions from renters about all sorts of things, running the gamut from maintenance issues to can my landlord actually do that? We knew that you would be the perfect person to come in and answer these questions and tell us legally, can they do that? We want to give everybody sort of just a heads up. This is not legal advice. You are an attorney, but really we're just using your wisdom on these issues of state law and sort of what people can do, who they can complain to, and if they have a leg to stand on, if they think that their landlord may be in violation of some sort of law. First up, we've done a lot of stories on renters and help paying your rent since right when the pandemic started. I mean, what's it like today what's the state of renting in Texas right now?
The state of renting is that it's a landlord's market, that there are usually multiple applicants for every unit in every complex. And so there is a high incentive to turn over a lease that may be on a grandfathered lower rate. Mm-hmm. So we're seeing a lot of turnover, both in the form of evictions and non-renewals of leases.
Yeah, I mean, we've done so many of those stories, too, that it costs so much to rent. I mean, interest rates are up, so it's not as if people always have the option to buy a home. But so then you're renting apartments or homes at much higher rental rates than we have in years past.
Yes, and it's not just the interest rates. There are lots of barriers to buying a home. The fundamental thing you need to understand about low-income and even middle-income people is the lack of liquid savings. And so it's hard enough for someone to come up with deposit and first month's rent for new apartments, much less come up with a down payment for a house. And if they do, they're looking at PMI, they're looking at a lot of extra expenses that set them up for failure from the beginning.
And Eric, I mean, you said that exactly right, because so many times I'll get emails and questions from these people who, maybe want me to step in as a reporter and knock on the management complex, their door and say, why are you doing this? And I always have to say, if I do that, it's not necessarily going to make it any easier for you to live there, or be prepared that if I do that, if they are already breaking the law, they're going to find some way to, something that they say you're doing wrong to evict you. I mean, it's tough because people don't just have the means to pick up and just move if you don't feel like your landlord's treating you right.
Right. And also the answer to that question is always the same. Why are they doing that? Because they can.
Yeah, they can. And then real quick, before we get into some of these questions, tell me about the Eviction Right to Counsel. I mean, how long has that department of the Lone Star Legal Aid been around, and what do you guys do?
So the Eviction Right to Counsel unit goes into just the peace courts, which have original jurisdiction, meaning they're the only place where you can file an eviction. Mm-hmm. And there are 16 in Harris County, and we, along with our partners in the Eviction Defense Coalition, the 3 law schools locally, as well as Houston Volunteer Lawyers, we all go into these courts, and we provide on-the-spot advice and representation for tenants who are facing eviction. We also take cases we get a lot of people who call or apply online to Lone Star Legal Aid, and we will also look at those and see if we can assist those people if they qualify. So that's our mission, and we've been around since 2020.
Yeah. In the show notes for this show, we're going to put all the contact information on how you can reach Lone Star Legal Aid if you're listening to this and think like, man, I sure could use advice or help in court. I mean, the Justice of the Peace Court is supposed to be a court where you feel like you may not need legal representation. You should be able to do it by yourself, but that's not always the case in these.
It's never the case for a tenant. If you look at the representation rates, they're very low, but the success rates, especially in some of the more unfriendly courts, when you have an attorney, are much, much, much higher. And so there is no question empirically that having an attorney improve your chances at avoiding eviction.
All right. And so I know some days you guys show up in court and help people who maybe have never heard of you until they show up to sort of, it's them versus their landlord. And then you're able to, on the spot, offer them some help?
Sometimes. It depends on a lot of factors. We do have eligibility requirements that are mostly based on income and citizenship. And if you pass those, then if we're there, you should at least be getting some advice based on your case. But sometimes we are able to actually walk into the courtroom as the tenant's lawyer, represent them on the spot, and hopefully do something to mitigate the damage of the eviction.
Okay. Yeah. I mean, because if you're a tenant, you've never been in a courtroom before, having to stand before a judge and, submit evidence, you may not realize if a judge does something or rules some way that is not the way it's supposed to work unless you have an attorney with you.
I've seen people come out of the courthouse and they didn't even know whether they won or lost.
Wow. Let's start with evictions. I mean, since that's sort of the subject that we're on and people winding up in JP courts because they're facing eviction. A lot of people want to know if a landlord can legally, without notice, lock me out. I come home from work one day, maybe I was behind on my rent. Can they just change my locks and lock me out, but they didn't give me any sort of notice?
Absolutely not. Here's the thing about lockouts in Texas. They're a bit useless legally because if a landlord locks a tenant out, there are notice requirements. There are 2 notices they have to give you, one several days in advance and one when they lock you out, saying that we're going to lock you out for non-payment of rent, and then we have locked you out for non-payment of rent. However, the key is, no pun intended, they have to give you a new key to the lock. They have to, 24/7. So they have to provide a number on there that says you can call this number anytime, any day, and you can come and get a new key. You do not have to pay your rent to get a new key.
And is that designed just to force the tenant to talk to the landlord?
Let me put it
show
this
their
way.
face?
I have never in my career seen a landlord follow the rules.
Really?
That lockouts are, for some of these landlord-tenant issues, like security deposits. Look at it this way. For a security deposit, if a landlord wrongfully withholds your security deposit, you can sue them and get not only the part that they withheld, but what we call treble damages, 3 times what they wrongfully withheld. That's great, right? But if a landlord is doing this to everybody and 1 in 50 sue them, they're still getting 46 deposits. Right?
Yeah.
So same thing with a lockout, that the vast majority of people are not going to know that they have rights they can enforce. So they just lock them out and say, well, if we get a call from an attorney, maybe then we'll take the lock off. But the chances of these people actually suing us, the chances of these people actually coming after us for doing this is almost none. So we're going to just do it. Ultimately, they may be bluffing. Sometimes they do say, we're going to lock you out, we're going to lock you out, we're going to lock you out, and they never do because they know that legally it's a bit stupid. But yeah, we don't see legal lockouts ever. And so if a landlord locks you out, I don't care if they gave you notice. You need to ask them for a key.
All right. So okay, very good point. That's what I was going to say, because normally if this lockout occurs and I'm just coming home from work and I've got, small children with me, I'm thinking, okay, so they weren't supposed to do this, but what do I do now? It's 8:00 at night. Right.
And you should not use violence to re-enter your place, but you can open a window and break in, right? Like it's your place, right? They can't legally exclude you from it. You have to be able to get a key. And if they are not giving you a key, that's a problem for them, and you can sue them and get extra damages because of it. But more importantly, you can get in your place. It's your place. So, don't take a hatchet to the door. But definitely if you can find a way in, if thankfully you left that window unlocked, you left the back door, whatever it was, then you can absolutely enter your place after you've been locked out, because they do have to let you back in anyway.
Okay. All right. I think we've covered one of the most common questions that we get. And as we go along with some of these, we're going to take a break when we go along. Each one I'm going to ask you, can they do this? And if they do, what should I do? Because that's sort of the, sure, I can take them to court, but in the meantime, sort of what can I do? Yep. Thanks so much for coming in. You guys stay right there. We'll be right back with some of the most commonly asked questions we get from renters about their rights. Welcome back to this Ask Amy, all about renters' rights and can my landlord do that? I hear these questions from you guys all the time. So I've invited Eric Kwartler with Lone Star Legal Aid, the managing attorney of the Eviction Right to Counsel, to come and answer some of these questions. So one thing that you just said to me that you want to make sure that people hear is what you should do if you do receive a notice to vacate. So I'm going to let you tell people those steps and things that you should know that you need to do. But stick around because first I want you to get some answers to some of these commonly asked questions that we also get. You mentioned we talked about renters' deposits, and that's a common thing that they're not supposed to keep them, but they do because they don't know that the renters know that they can sue and get triple the amount of their deposit back. But some of the things that we hear about are maintenance issues, but it's a pretty big deal in Texas, in Houston, when your power goes out. But we will have apartment complexes where the entire complex is without power, which means no AC, no lights, no way to cook meals. And it might go on for 2 or 3 days. And the tenants call and say, oh my gosh, do I still have to pay for this? Can they legally do this?
Okay, so number one rule of a landlord-tenant relationship, always pay your rent. Because in Texas, there's no such thing as a rent strike. That's called a mass eviction. There's no such thing as withholding your rent because they won't do what they're supposed to do. There's a very minor provision allowing for repair and deduct. I have, in my career, never seen anyone do it right, so
Really?
don't try. It's got a lot of strings, and it's very limited. The bottom line is you cannot just say, well, they are not doing their job, so I'm not going to pay them for it. You have to pay your rent. And that's unfortunate because they shouldn't be able to collect rent if they're not providing a habitable premises. But as to power cutoffs, things like that, with a repair request, the landlord does have some leeway as long as they're making a diligent effort to repair the situation. And they have a reasonable amount of time to do it, which is presumed to be 7 days, but that's in a situation that's less dire than having no power. So it's one thing if the landlord is just saying, oh, we'll fix it, and they're not actually doing anything about it. But sometimes there are part shortages. Sometimes there are reasons why there are delays. And it's not reasonable to tell a landlord that we don't care that you're literally not able to do this. We're still going to sue you. This is still your fault.
Yeah, and so I think that a lot of people, you feel that when you're in your apartment or your home and there's no electricity, and they may tell you, well, I've called somebody, but it's going to take this amount of time for them to get here, or this amount of time to get this part. That is making that's making an effort.
Yeah, though calling someone is not necessarily a diligent effort if they know that they could call someone else and that it would get done faster. If they're just trying to save a buck because they want a cheaper person to come out, and you're going to leave all of your people without AC in the middle of the summer for a week because of it, that ain't gonna cut it.
Who can I call? So if I feel like my landlord is not making a diligent effort, even if they tell me that they are, but now we're going on day 2 or 3 in August with no electricity or no AC, is there somebody that I can report that to?
Well, you can call us. We do take some of these cases where a landlord is not doing what they're supposed to do or has locked someone out illegally or, things like that. And so we can see if we can try and help. But my first piece of advice is send a letter to your landlord by certified mail, return receipt requested, telling him or her or them that they need to make whatever repair it is. It has to be by certified mail.
Let's talk about that, because if I live in an apartment, a lot of these big management companies have portals for maintenance requests, or you go to the office and the person in the office writes down what your issue is, and you say, don't just do that. Explain why.
Yeah, and you said it exactly right. Don't just do that. You should do that, right? Use the normal channels. They're going to be faster than certified mail. But under the law, if you want to exercise your control, if you want to be able to get a judge to force a landlord to make a repair, the first step is to send a request by certified mail, return receipt requested, to the place you pay mail or pay rent. So you have to do that. But absolutely do the other things too.
I mean, that is frustrating, as you know, Eric, because sending a certified letter costs money.
And you have to go down the post office. It's very frustrating, I know. But it is still... we can't do anything about that unless the law is changed. So until it is, we still have to send our request by certified mail.
And I always tell people, make sure you're keeping very good notes. So when you're writing that certified letter, you can include in there, like, writing this to please, get you to fix such and such issue that I reported on this date and spoke to you about that date. I'm like, you can't write enough information in there on the record to keep those notes.
That's correct. And a couple of other things about these requests. One, in order to enforce them, you have to be current on your rent. So even if you're not, if this is a problem throughout the complex, then someone else may be, and they may be the right person to send that request by certified mail. So you need to make sure that I know it sounds ridiculous that you're behind on your rent and they can allow cockroaches to run through your place and it's no big deal. Well, that's technically the truth. So you want to make sure that that's one, why you always pay your rent, and two, why you're very diligent about these notes, like Amy said.
All right. And a lot of these are obviously health and safety issues when you get to a point where you might have a roach infestation or certainly no hot water to safely, clean things. And I said, well, could you report them to the health department? And your answer was?
Yeah, you can call code enforcement, but it is also important to understand that with these repair requests, the only things that you can ask to repair are conditions that would materially affect the health and safety of an ordinary tenant. Now, everything we've talked about so far definitely does, right? Roaches, no hot water, et cetera. But it's not going to work for your dishwasher.
Right. Yeah. Okay. All right, was great so far. When we come back, we're going to talk about that. If you get that notice to vacate, what you need to know. We're also going to let you know what you need to do. We've got some questions from people who are handicapped and want to know if their apartment complex is required to do certain things. We're going to get to all those questions when we come back. Welcome back to Ask Amy. We're talking all things renters' rights, and Eric Kwartler, managing attorney of Lone Star Legal Aid's Eviction Right to Counsel, is answering the questions. You wanted to make sure that people know what they should do if they get a notice to vacate. Say they come home, it's on their door, they're behind on rent, they knew they were behind on rent. You're saying don't vacate?
Yeah. So the real important thing to remember is a notice to vacate may say that you have to be out by 3 days from today, or else they'll file an eviction. An eviction is a lawsuit. It's a process. It's not the actual act of forcing you from your apartment or home. So it does not mean that if you're not out in 3 days, the constable will come and assist the landlord in removing you and all of your belongings from the apartment or home. That's not what it is. So don't self-evict, especially if self-evicting means you're going to be on the street or in an unsafe place. There is a process and there is help out there. But also keep a dialogue open with your landlord. Just because they gave you a notice to vacate doesn't mean they're going to file an eviction right away. So talk to them, see if you can get into a payment plan, and talk to someone about rental assistance, because there is some rental assistance still available.
Okay. All right. And we also know that we'll put in our show notes all the information on how to reach Lone Star Legal Aid. I'm not sure. I don't want to put you on the spot if you have that phone number to dial now.
I don't, but you can go to lonestarlegal.org.
lonestarlegal.org. All right. So one woman wrote us and she wanted to know, she had moved into an apartment complex and didn't realize that it wasn't outfitted with the ramps that she needs to be able to move over curbs and up and down stairs for her wheelchair. And she said, don't ADA requirements require the complex to put these in? They said we can, but you're going to have to pay for the ramps.
Yeah, so there are two laws here that are at play: the ADA, Americans with Disabilities Act, and the Fair Housing Act, FHA. The ADA applies to the public areas of the complex, like the office. And in that case, wheelchair accessibility is on the responsibility of the business, the place of public accommodation. Mm-hmm. However, for your apartment or home, that's covered by the Fair Housing Act. Now, the landlord can't refuse to put in a ramp, but the cost sharing is not actually illegal under the law, because the landlord does have to let you live there, but they don't have to pay thousands and thousands of dollars to do that for you.
Accommodate you. You might have to pay for some of those things. Yes,
you might have to pay for grab bars, for wheelchair ramps, for door widening, things like that. Yeah, some of that cost may be on the tenant.
All right, sort of on the same subject, seniors who live in some of these senior apartment complexes that are high rises, or at least like 8-10 stories high, get stuck because they were sold an apartment complex with elevators, and they may be on walkers or wheelchairs, and then the elevators break for weeks or months at a time. And they say, well, what can I do about it? Sure, the landlord says they're working on it, but in the meantime, I can't get downstairs or upstairs.
Yeah. So in an apartment complex, the landlord cannot create a situation or allow a situation to continue that makes it impossible for the tenants to live there. And in that case, even if the seniors are still in their apartments because they can't get down, that doesn't mean they haven't been what we call constructively evicted. Basically, the landlord has created the situation or allowed the situation to continue that they might as well have put a dumpster in front of the door of the building because that would be the same level of barrier that a not working elevator would be to someone who uses a wheelchair. So yeah, that's a real problem for them, especially if this is a seniors only complex and the elevator's in the lease.
Yeah.
So if the elevator's in the lease and they're not taking the steps they need to do to fix it, they've breached the contract. So there are a couple things here, and I would definitely say contact a lawyer, contact us.
Okay. All right. What about raising rent? I mean, I think it's almost a given with any sort of bill these days, but that, when my lease is up, they're going to raise my rent. And people want to know, it's Texas, it's not New York City, where we've heard of rent-controlled apartments. Can they raise it as much as they want, as often as they want?
Basically. In Texas, there are very few protections for renters, as you said. There are basically no realistic limits on the amount that they can raise the rent, but they cannot raise it during the lease. So if they try to raise your rent during the lease, then that's no good. But once the lease expires, you're now month to month. And so with 30 days notice, they can raise your rent even if they don't tell you have to be out.
Okay. We're starting to see recently a big investment group that had purchased 3 or 4 apartment complexes in the Houston area. You probably heard about it. They got foreclosed on. And so all of these people, it's like 3,200 apartment units, were going to be under new management. When first they were foreclosed on, finally a new investment group came in and purchased them up. But when that happens, when my apartment complex is sold, do any of my provisions, my lease, any of the agreement with the former owner change?
No. They do not. Everything that was in place should remain, despite the fact that the complex has changed hands, whether it's foreclosed on or not. If someone buys it, they buy the lease as is. They buy the debt to you for your security deposit. So none of that changes just because you paid a different person.
Okay. And then we hear a ton about people moving into apartment complexes because they liked the fact that they had surveillance cameras monitoring cars in the parking lot. They liked the fact that they had the gates, and they love all of this until they don't work. The security gate is stuck open for weeks at a time, and then they go to request surveillance video and find out that they weren't actually recording anything in the parking lot. Can I do anything about that?
No. The security measures in apartment complexes are what we call security theater. They make it look like it's safe. I can tell you that I personally had my apartment broken into years ago because a gate was left open during the holidays. So, and there was nothing I could do. This was before I was a lawyer, but even if I had been, I couldn't have done anything about it. It's just theater. It's just making it look like it's safe.
And so does my apartment complex have to tell me about any crime on property? Certainly, I'd like to know if my neighbor's apartment was broken into or there was a sexual assault on the property. What obligation do they have to share any of those details?
Normally none. There may be certain things with regard to sex offenders living in the apartment, but even then, probably not. They don't have a whole lot of obligations to you at all.
Okay. All right. So most important thing that you would like renters to know, if you are having an issue with your landlord, some steps that you think your landlord needs to take that is sort of putting you in harm's way, or whether it's no AC, whether it's no hot water. I mean, what are the things that renters need to know in our final minute that we're wrapping up here?
Number one, keep paying your rent. If you can pay your rent, you pay it, period. That's not an economic decision. I understand if it's a choice between lights, if it's a choice between food, those are difficult choices to make, but don't stop paying your rent because you don't think you should have to pay it. Always pay your rent. That's the number. If you don't get anything from this but that, then you've gotten something very important.
All right. And I would imagine the very next step would be, if you need help, try calling Lone Star Legal Aid.
Absolutely.
You will find all of that contact information in our show notes. Thank you so much for joining us today. And thank you for tuning in. If you've got an idea for a segment for Ask Amy, don't hesitate to reach out at askamy@kprc.com, and have a great day.